Originally, I wasn't going to do a video on this, but I've heard so many people repeating this same thing.
The defense wouldn't even be able to argue alternate perpetrator theory without already meeting the threshold that it exists. You understand? They already met that burden.
No, they didn't already meet the burden. That's why there's a hearing on the 18th. The threshold is going to be looked at on the 18th. And Judge Hippler will decide whether they meet the rules of evidence or not to submit the some other guy did it defense. Just because they filed a proffer and filed evidence in support of their proffer doesn't mean they met the burden. I hear so many people saying the same thing that Ms. Potts said, or saying the judge accepted it. No, he didn't accept it. Just because it's been filed doesn't mean it's admissible. The hearing on the 18th is to decide if he will allow the third-party defense information to be admissible at trial.
Do not tell the fucking defense in the state, okay, months ago, that half the shit they're filing under seal doesn't meet the burden, doesn't meet the standard, shouldn't be filed under seal, and then go ahead, but the alternate perpetrator, oh, everybody clutch their fucking pearls. Nobody can see that.
Okay, you said it right there. Burden. Okay, half of what they're filing doesn't meet the burden or the standard. But half of what they file does meet the burden and the standard for getting something sealed. If Hippler's agreeing to seal something, it's because there's a very good reason under the law why. And you've seen him unseal things, okay? So it's not like he's just sealing everything. But alternate perpetrator proffer, when it hasn't even had the hearing yet to determine admissibility, that is going to stay sealed for the safety of the people that are being named in that. You can't just throw names out there willy-nilly. That's why if you're going to do an alternate suspect defense and you're naming someone, there has to be actual proof that's admissible under Idaho rules of evidence. Otherwise, you can't just throw a name out there. That would be completely reckless, completely dangerous. And that's why this is sealed. And then if his decision is made that it's admissible, I'm sure you will see that unsealed.